I would think that that would be a great thing because in some situations you need to get out of there. The stress factor is in the best interest of the child for someone to leave and diffuse the situation. That's
It
good.
is. Another factor in the 2005 law, the willingness of each parent to facilitate and encourage continuing parent-child relationship with the other parent. So there again, that's actually part of the law. It's only one of 14 factors that judges need to consider. And there's a whole lot of discretion that judges have about the best interest of the child. But still, there's that guidance that we think should be emphasized by judges and by mediators and counselors of all sorts in the process of divorce. And parents should ask themselves, what am I doing to facilitate and encourage the other parent?
Right.
And that would just that attitude, if that attitude changed,
Yeah.
so much would change in the state of Connecticut and it would definitely help children.
Certainly that talk case was probably the extreme example of not working
yes.
together.
Yeah, we did do an analysis of Tauk versus Tauk, a very high-profile case in the state of Connecticut.
Mhm.
Do you know anything about this, Father Ross?
I don't know about the Tauk case, obviously, I know about the Rubenstein case, but I don't know about Tauk versus Tauk.
Well, I think one of the defining things of the Tauk case is the amount of money involved. It's an astronomical sum of money. I had to look it up, actually. It's so
I think it
mind-boggling.
was like $13 million.
$13 million that the Tauk case cost. That's right. Unbelievable. 86 days of trial. I mean, you're talking about going to court and having trial in front of a jury. 86 days. And then after the trial ended, there were 40 motions filed by the two sides in the case during a 2-month period after the end of the case before the judge could make a decision. And the judge was Judge Holly Avery Whetstone, and she said at one point, there's no way I can render a decision in this case until you lawyers stop filing motions. I'm overwhelmed. She kind of implied she was overwhelmed by motions in the case. And there were 4 children involved in that. There were allegations of child abuse that were proved incorrect in that case. And on a human level, we think that these false allegations of child abuse that are sometimes used in these custody battles, it's just a horrible thing to do to children, to falsely accuse the other parent. And yet, unfortunately, that happens in some cases. Even one case is too many, and it happened in the Tauk versus Tauk case.
A unpublished study that I know was done in New Hampshire. A group of psychiatrists and other counselors surveyed in the area what percentage of these allegations are not true, and the response was that 80% were not true.
Wow.
It just uses a tactic to gain the upper hand in divorce and custody situations.
I would, the problem that I see in that is that then we have the difficulty of those things that are true.
Right.
What do you do? We have okay, so basically we have lawyers or people using a tactic, okay, that is, do they know it's untrue? Do they have the substantial professionals to say they're true or they're not true versus someone that goes in there that then are true, and where does that put us? You jam with a study that says 80% of them are falsification. Well, that means 20% are right. So how do you wade through that?
I think that's a tough one, but I do think that there should be some very substantial consequences for the false allegations, because then that would cut down.
Yeah.
That would cut down. If you really had consequences for the false allegations, I think that would then cut down on those, and you could get to the ones that are correct and are true, and where you need to protect children from the abuse of a parent.
Yeah, yeah, you know, I would think that that is a horrific situation. I mean, it's, I don't even know what way to approach or how you deal with a situation like that.
I think one of the things, you know, I think, well, all of us at this table have gone through a situation where we've gone through a separation and dealing with that. And in talking to a lot of people, I think one of the things that often happens in that process, looking at it in retrospect, is there's oftentimes a lot of suspicion on the other parent's part because you don't know what's going on. You've gone from a situation where you're involved and you know what's going on day to day, and then you're in a situation where you don't know. And something fairly minor, that a bruise on a child, could be simply from playing. But then you don't have contact with the other parent, you have an acrimonious relationship, and people start to get paranoid, and then you talk to your attorney, who then says, oh, well, we can look into that.
Yeah.
So it kind of snowballs. So looking on both sides of, you know, how much of this is just me not knowing and me being scared, which there's some validity to, but how much of that is kind of what I'm feeling and going through versus how much of it is something that might be more than just a bruise. And I think we all have to look at that in that process, whether it's the parents, whether it's those that are involved in the court system, and trying to hash those things out and trying to be realistic with ourselves about what is what, and trying to think about the best of what's going on as opposed to the worst. But as we get into the court system, we start thinking about the worst and all the bad things, and which is really why we come back to trying to get parents to work together to resolve issues and getting the court to support that.
A lot of that goes back to if the parents have joint custody and substantial equal time, we've now eliminated all of these factors. I mean, there is no advantage to try to claim this if there's consequences for false claims. There's no advantage for trying to get extra time. There's no advantage to fight it out. Keep
Right.
it simple, mediate it.
And you're involved, both parents are involved, so they know what's going on more.
And well, from what we've heard with a lot of people, once you get the courts involved, especially if it's a high conflict case, I don't know if many of you viewers know this, the kids get their own attorneys, called a guardian ad litem.
Ad litem, that's.
And each of those attorneys, they get paid, and each kid may have a separate attorney.
I didn't get paid.
You should
I
have.
should have.
I'm sure you did a great job.
I should have been.
You didn't send a bill.
I should have been. I didn't realize. Well, I should have been paid. You've got to be kidding. What they, I heard what one guardian ad litem got out of one case was over $100,000. I said, you got $100,000 for being the child's what? Attorney? Okay, and I mean that puts an interest on you if you're getting paid, okay, that kind of money, you know, and
If you're getting paid by the hour, there's not a lot of incentive to end it quickly.
no, of course not, and you might and you can agitate both sides.
Right.
Because you're the child's attorney.
Right.
It's the best interest of the child. I see, you got to be kidding me. I mean, this is.
Well, we've heard of many of these, divorce and custody situations where many people in and out of our group have told us that basically things got settled once there was no more available assets.
Yeah.
The attorneys couldn't get anything else.
They couldn't get anything else. I mean, it can be horrific. I just,
In fact, one law that we would like to reverse that is on the books in Connecticut, and it has to do with the paying for college. So it turns out in the divorce situation, the non-custodial parent is required to pay something for college. Now, an intact family is not required to send their child to college, is not required to pay for college. But in a divorce situation, there is a law extending child support essentially beyond age 18 to pay for, college, and it's defined as some percentage of UConn tuition, et cetera, et cetera. But we think that's a very negative thing to have because it increases the stakes, and then you need a guardian ad litem for the child because the child has an interest in making sure that the college payment is there and enforced.
I lucked out. I lucked out. Have 2 children, okay?
Right.
Of course, I've been blessed with serious sports kids. We've got scholarships to universities and everything on their sports ability. Well, in the last the two that, okay, one got her scholarship to college, and after